Okay, we're on. I apologize for the delay. I am coming from a new office location, so I was just getting familiar with the setup. So tonight we're going to talk about the highest court in the land, the Supreme Court. This court was once described by Justice Roberts during his confirmation hearing as an institution where 9 people in black robes simply call balls and strikes. So who would have thought it would be so contentious, but it is, because we're less than a week away from a presidential election, and we just had a recent justice get confirmed and sworn in as the next associate justice. So that will be tonight's topic. The last time we spoke about the Supreme Court, it was in the wake of the passing of the late Justice Ginsburg, and we were sort of pondering on who is going to replace her, and now we know the answer. So I guess before we get into Justice Barrett's background and qualifications, maybe we could talk a little bit more about how we got here. So maybe, can anyone explain the Mitch McConnell rule? Any takers? Okay. I guess the most charitable way to describe the Mitch McConnell rule goes like this. In an election year, you don't want the president to weigh in, especially if the Senate is not controlled by the same party as the president. And under Article 2, Section 2 of the Constitution, the role of the Senate is to advise and consent. So if the Senate is in a different party than the sitting president, then, well, why disturb the will of the people? Why not let the people decide, so to speak? Do you find that argument to be convincing or no? Anyone?
No, it's not very convincing.
Okay, and tell us why.
At least in my estimation. So the way that McConnell went about it, and the reason why it's so, in my estimation, so you guys can agree to disagree, so repugnant, is because the Senate's role is to advise and consent. And so you can take up the nomination and simply not pass it through. If you control the Senate, you can at least take up the nomination. But to brandy about this idea that, oh, we can't even consider the nomination, it's too soon, close to the election, et cetera, I guess, you know what, excuse me, let me back up. The best way to put it is this: I believe the late Justice Ginsburg said a president is elected to serve for 4 years, correct? Not 1 year or what have you. So their reasoning in taking up Justice Barrett's nomination was that, well, the president is elected to 4 years, and if this happened in the 4th year of his term, then he should be able to nominate whomever, and the Senate has to take it up. Except that did not wash when it came to President Obama. He was also elected to serve 4 years twice. And so regardless of whether or not the Senate was in the same party as him, it's not their job to completely ignore a president's nomination. They can choose to not confirm the person, that is well within their rights, but to ignore it completely and not even take it up, that's not respecting the will of the people in any way, shape, or form. I can't hear you. I don't know what you just said. I don't know if it's me or you.
You're muted.
No, it's me. Sorry about that. I'm still getting used to this setup. Isn't it the role of the Senate to advise and consent the president? So if the Senate says, the Judiciary Committee says, well, we're not going to let the president put the nominee up for a vote, then isn't it within their purview to say, we're going to block any name or nominee from being introduced for a vote?
I would say, I would guess so, because they obviously did it.
Yeah. Okay,
I mean,
let's go with
I'm not saying that it certainly wasn't the right thing to do, but it was done and it can't be taken back now.
Okay, let's go to some other members. Earl, then Annat.
Yeah, Thomas, you were overly easy on McConnell. McConnell's rule is simple. If you have the political power to do something, you do it. If you don't have the political power to do something, you bitch about not being able to do it. That's the McConnell rule. All of this stuff about oh, the will of the people, and you know, Lindsey Graham talking about it. That's all surface manifestations. It's all distractions. It's all crap. McConnell will push through the nomination of Barrett because they need six conservatives in case the cases that are threatening to send them all to jail get to the Supreme Court. This is MASH. This is meatball surgery. There isn't anything erudite about what McConnell did. It was very predictable, and anybody who's ever met the man and followed his career knows that he doesn't believe any of this crap about, you know, in the year of the election or in the last year. He doesn't believe any of that stuff. What he believes is if you have political power to achieve your objectives, you do it. And if you don't, you bitch about not having the power.
Okay, so what I'm hearing from Earl is that the ends do not justify the means. However, to McConnell's credit, there is some sort of constitutional authority that gives the Senate to at least name the nominee. I'll just read you an excerpt of Article 2, Section 2. The president shall have power and the advice and consent of the Senate to make treaties and also appoint and nominate ambassadors, public ministers, consuls, and judges to the Supreme Court. So if you were to follow the black letter law of the Constitution, it's right there. So what's there to argue? Isn't the argument over?
It also says that the Senate is supposed to be part of the legislative body, right? That they're supposed to legislate and do things that are in the best interest of the people. And as far as I'm aware, they've spent the last however many years shoving through judges and passing no sort of legislation that actually helps anyone. So, I mean, at the end of the day, yes, what is in the Constitution is there, but this is not a group of people that actually follows that.
Right. I guess I would look at this almost like, you know, if you're a good lawyer, you use the law to your own advantage, whether if it's tax law or criminal law, you always try to game it in a sense that it's going to give you the competitive advantage than the other side. And this is pretty common. So to me, I think just again, based on the face of it, seems like there's nothing unethical that Mitch McConnell has done, but I see other objections from others. Let's go to some other members. What about Annat and Amber?
Thanks, Thomas. Something I'm confused about is why advice and consent of the Senate is construed to mean that the Senate can simply, or the Senate leader can simply not consider a nominee. Like, I would have expected at least an up-down vote on Merrick Garland. It just seems like it's partly because the Senate's part of the legislative branch. I kind of feel like it's like interference. So that's the first thing. The second thing is I don't think it should matter if the Senate's the same party as the president or not. You know, if we elect the president for 4 years, then they should get to, put up a nominee when there's a vacancy. So that's similar to what others have said. The third piece of this is I was thinking about, this isn't the same thing, but like when there's an impeachment, the majority leader in the Senate cannot say something like, oh, well, we're just gonna schedule it 8 months out or further out, right? That would not be considered acceptable. But for Supreme Court nominee, why is that okay? I mean, it's definitely just as important. So at least for me. So that's how
I think you're right. I think their logic is really twisted into like a pretzel. There's no consistency. I was trying to find something to at least show some authority and apply the authority to the current situation. But again, what is the McConnell rule? That's really what I'm getting at. And I'm not sure if there is, other than just game the system to your partisan advantage, and that's it. You know, I mean, I don't want to make too much of a partisan statement, but I'm trying to find a way that would make sense and that would be fair to both sides. Let's go with.
The thing is he calls himself the Grim Reaper of the Congress, and so unfortunately, there's no sense in it. And he plays the long game. There is that, but there's no like, oh, this is the right thing to do, and that's why I'm doing it. That's not. It's very much a we have the power. We're not afraid to use it to our advantage, and I think it was Earl who said it earlier. And if you're not the party that's in power, bitch and moan, but oh well. But, you know, like they say, elections have consequences. So these are the consequences.
Yeah. Let's go to some other members. Amber, then both Ralphs. Amber?
Well, I mean, I expecting Mitch McConnell to be like some high moral, upstanding human being is pretty much asking a lot. The man literally said that he would do everything he can to obstruct President Obama. So that in itself was, dereliction of duty in my view. But he knows how to play the game, because by all accounts, everything he did was legal. He didn't miss any steps. His reasoning when he didn't confirm Merrick Garland, sounded sound, and sounded on the up and up. The people should have a say in the next Supreme Court person that goes there. But then now all of a sudden it's well, technically you're a president for 4 years, and so there's no reason why you can't confirm anyone. And the skilled litigator, as Ted Cruz comes up with this reasoning that in the 29 times that you've had situations like this where a Supreme Court seat opens up during an election, only I think he said only 19 times where they confirmed when it was the same party. And I'm like, okay, well, you know what? If this was always the logic, well, why didn't you just say that when you didn't confirm Garland? That you could have just said that. But no, you pretended like you were taking the high road and you really cared about what the American people wanted. So, I mean, on the one hand, as Tara said, election has consequences. So those who are like boo-hooing it now, well, I mean, you knew what you were getting. You knew what you were getting in Mitch McConnell, and a lot of people didn't vote. So you can't really, be upset about it now. But at the same time, the same thing applies. Elections have consequences. So if Republicans are no longer in power, they cannot expect to hold Democrats to any higher standards. I think the whole Democrats taking the high road died when Trump became president. So I don't know, who does this serve, because apparently America is not important to either side.
Okay. It sounds like what I'm hearing from Amber is maybe the Democrats back in 2016 were a bit too passive. Maybe they should have done something just to kind of rattle the cages of the other side, but they didn't. Maybe taking the high road sometimes doesn't pay off in terms of getting their nominees to the bench. Let's go to some other members. I see both Ralphs. Whichever one, go ahead first.
Okay, did I get in first? I guess so.
Go ahead.
All right. I just briefly, I think the ratification of the nomination of Barrett was perfectly legal and constitutional. It was blatantly hypocritical, of course. And I think that McConnell's blocking of the nomination, of even consideration of the nomination of Garland, was a violation of the Constitution. It was at least a violation of the spirit of the Constitution, but I think it was unconstitutional. And somehow it kind of surprises me that the Democrats couldn't have found some legal recourse in this, at least an effort at legal recourse. You know, sometimes Democrats don't seem to know how to fight.
Okay. I guess I pretty much agree with Earl. The law is the law, and the rest is all just spin. The Constitution is very clear. The president nominates and appoints justices to the Supreme Court with the consent of the Senate. And that means that, so they have to have the consent of the Senate. If they don't have the consent, then the appointment does not go through. And you can consent either by saying no or by just not consenting. So yeah, there's nothing illegal. I wouldn't say there's anything unconstitutional. If the Senate has every right to block a nomination, and how they do it is irrelevant. I guess I'm a bit of a legal realist there. The law is the law. Certainly at this point, the Democrats would do exactly the same thing. So yeah, and it seems to me accusing a politician of hypocrisy is kind of pointless. Politicians, there's the old statement, how do you know when a politician is lying? When he's opening his mouth. Politicians do whatever they have to do. The main job of a politician is to get elected. To say that politicians shouldn't sort of take the moral high ground or should take the moral high ground, that's not the way it works. And I don't think there's much point in demanding it. The law is the law, and that's it. And it's perfectly straightforward in this case. Thanks.
Thomas, just to break in for a minute, could you let people know how to raise their hand? There's a couple of newbies here, and they on the chat line, they've been asking about it. I've been trying to direct them to the participant logo at the bottom and to have them click their hands. But you got a couple of them here who are anxious to speak but are not getting in line with you.
No, it was me, but I figured it out. Thanks, Earl.
I think Thomas, you're on mute.
For others, just for your own application, just right click on your name under participants and you'll see an option to raise your hand, and then the blue logo will show up. Okay, before we move on to, I guess, the judicial philosophy of Justice Barrett, I just want to get to some other members here. So we have Dave, then Kalin.
Good evening. I think that we underestimate that Congress, there are a lot of people in Congress that say, because they're mentioned first in the Constitution, that therefore they're the most important. And I think that that's part of the reason why the Senate might decide, or the House might decide, that they're more important than the president or the judiciary. The other thing is, McConnell obviously miscalculated when he said that he didn't want to do a nomination in the election year. He didn't mention the part about party because he didn't expect a liberal was going to somehow leave the court this year, as opposed to 4 years ago. So I think that's the point. But it's fair to say that the Senate clearly is taking a much more significant role in the advising consent. I mean, isn't it true that for most of history, it was pretty much a rubber stamp? And it's only been in the last couple of decades that there's been a lot of hearings and a lot of attention paid to it.
Right, and even the argument that let's let the people decide is constitutionally not entirely correct, because again, there's no direct democracy. We vote through electoral college. So this notion that the will of the people will then be translated into the nomination of Supreme Court justice is quite indirect, let's just say. Okay, let's go to Kalin, then Pedro.
McConnell just used all legal moves in his power to follow his agenda, and his statements, if we take them as solid arguments, we are missing this particular portion that he's following his agenda in any possible ways. And this kind of behavior, his behavior has a history. It dates back before the Tea Party movement, and it starts from a Democrats than boycotting conservative nomination from Supreme Court. Unfortunately, I cannot remember exact year when it happened, but it was Senator Kennedy who organized the Senate Democrats to boycott, and they even refused to speak with the nominee. So some claim that this was the point of time when McConnell formed his agenda, and he was determined to boycott in all possible ways, all democratic efforts to fill court judge positions that are opening, both in the federal courts and the Supreme Court. So it further can be looked through the perspective of a distant reaction to the Warren Court and concerns that Supreme Court will be more liberal. But providing this kind of history, I think it is important just to point that if we take his arguments that he openly articulated, we are missing the point that he is using any possible way to pack the court with the conservative judges. And he will use and say whatever it is in accordance with the situation.
Right, that's a good point. Up until, I guess, Robert Bork in the 80s, it was like this unwritten rule on Capitol Hill that a sitting president, that's his prerogative to make the nomination while his term is still active. And the question really becomes, who fired the first shot? Because obviously the nomination process has become highly vitriolic. And well, I think if you were to trace back to history, as Kalin suggested, once upon a time, it was just a rubber stamp process, or maybe, near unanimous, like 97-0, and 3, absentee votes. But now, I think ever since Robert Bork nomination, that we had the Clarence Thomas nominations, and then, I guess most recently, before Justice Barrett, the Kavanaugh hearings were quite contentious, where we had wall-to-wall coverage for like a month almost. Oh, and one last point I want to bring up. On the note of McConnell's, I guess, stated reasons, some of you might not find it convincing, and he talked about how we'll let the people decide. I think in this election right now, I believe by the time Justice Barrett's name was already put out there, something like 5 million voters already voted by vote by mail. So if you go by the rationale of let the people decide, well, they already decided, so you can't just undo the vote. Doesn't work that way retrospectively, retroactively. So I'm not sure if that argument really is persuasive. Okay, Pedro, then Caleb.
Hi guys, greetings from Tijuana, Mexico. I kind of just stumbled upon your group. And I was looking at something interesting on Meetup, and you guys seem kind of cool. So I hope you don't mind if I'm butting in. I'm not from New York. Any case, I remember the Merrick Garland confirmation. I was in law school when it happened. And to be honest, what happened this time doesn't really surprise me. As far as legality is concerned, it works. The confirmation is completely legal. The president nominated, the Senate confirmed. There's really nothing to be done. I think the point where the Democratic Party should have done something was during the Merrick Garland confirmation. Specifically, they should have called the lack of a hearing for Merrick Garland as dereliction of duty on the part of the Senate. The process is that the president has to nominate, and then the next step is advice and consent. They didn't advise, they didn't consent, they didn't even have a hearing. I mean, one thing would have been they would have done the show, had the committee, had Merrick Garland there. And then at the end of the process, they would have said, no, we don't like him, we don't consent. Okay, at the very least, they performed their function. They performed their constitutional duty. But they didn't even give Merrick Garland a hearing, which is completely like a dereliction of duty. It's like not showing up for work. At that point, the president could have been like, oh, okay, you don't want to have a hearing for Merrick Garland. Okay, I guess I accept your resignation and appoint a new senator, because they had to advise and consent. They didn't advise, they didn't consent, they refused to hold any type of hearing. I think that was the point where the Democratic Party failed, because they should have at least had a hearing. Even if it was a show, it was a Republican-controlled Senate, but they still had to have that hearing. and they still had to advise in consent or not consent, and then not consent, but they didn't go that far. So I think that's where the error was. I can't really argue with what's going on now. As far as legality is concerned, I don't see anything wrong with it. It's hypocritical. It's hypocritical from a moral standpoint, but legally, I don't see an issue with it.
One thing the Republicans are very good at is to create theatrics and ruckus. And I think, again, not that the Democratic Party needs any unsolicited advice from me, but if I were to recommend that, I would say shut down the government, shut it down for a month. Yes, I know there's going to be people who will be furloughed and who will suffer economically, but get the message out there. The government has a job to do, and when you don't do your job, as Pedro has indicated, their election of duty, then, well, nothing sounds the alarm to the public other than shutting down the government. Now, is that a good practice to get into? Probably not. But I think sometimes from what I've learned about the Democratic Party is that they try to be too professional and they want to please everybody all the time. And it seems like they're kind of all over the map when it comes to this. And sometimes being cordial just doesn't work out. So, the message of when they go low, we go high, it's a good slogan, but I'm not sure if that really brings you victories on the bench. Just one last note on Merrick Garland. He'll certainly go down as kind of like a footnote in history, because if you look at his nomination when he got to the federal circuit bench, I mean, he was confirmed unanimously. And if you look at the previous Judiciary Committee member's comment, I think it was Orrin Hatch of Utah, he had this glowing remark about how Merrick Garland is like this steward of, legal precedents, a model jurist. And he was by no means, somebody like Justice Ginsburg or Sotomayor. He was a very just middle of the road, a realist when it came to his role as being a judge. So I'm just very surprised that it seems like they picked the wrong battle with the wrong person. They could have, maybe went after somebody more, I guess, to the left. Okay, we do want to move on to Justice Barrett's judicial philosophy, but I know Caleb, you had your hand up, so we'll go to you next, and then we're going to move on to Justice Barrett's philosophy. So go ahead, Caleb.
So my only thoughts after this is, well, I think both parties are playing a game of power. Obviously, that if Democrats weren't doing it before, which I think they were to some extent, they're going to do it now, which is use their power to their advantage, and Republicans are going to do the same to the extent possible legally. And these questions of like moral barriers, or barriers of precedent are going to crumble more and more. And I think what that does is it makes actions done by each party a little bit more radical each time in reaction. So now, as the Republicans have decided to, first of all, not confirm the previous justice, confirm this one, breaking their own precedent, and a precedent that, has been around for some time. Democrats are now talking about packing the court, and a couple have already openly supported that idea. That is a precedent that has been around for 100 and something years. And so that's the other shift. So when you get, a little bit more radicalism on one side, you get more, kind of like, we're going to use our power to the greatest extent now too. And so it is, I think it's legal. I'm not, as far as I've heard, it's legal to nominate another judge to the court. And, clearly they're thinking about it, because both Kamala Harris and Biden refused to answer the question during the debates on whether they would pack the court. And there have been Democrats who've openly supported it. I think AOC, very outspoken person in the Democratic Party, has said pack the court openly on Twitter. So I guess now it's just going to be a game of power, and whoever wins wins, and everyone's just going to follow the law and bend it. Not even just follow the law, maybe use it to their advantage as much as possible. So that's just my thoughts.
Yeah, that's a good point. And we'll get further into that topic when we go into the breakout room. But I think what Caleb is illustrating here is that, or this ominous sign that there's going to be this kind of judicial arms race, kind of like what we saw with the nuclear arms race back in the 80s. I think here it's going to be, well, who could pack the court faster, and it's just going to get out of control. So then what's going to happen? That's something we're going to save for the breakout room. But what about, let's talk about who Justice Barrett is. Again, who is Amy Coney Barrett? What's her background? What's her qualification? Does anyone know anything about that? Any hands? Let's see. Sandy?
Yeah, so she's been groomed for this for decades. So when she started in law school, a group of her professors kind of picked her out and thought she had a great future as a conservative jurist. So they got her a clerkship with Scalia. And then later on, they as a group got her onto the faculty at Notre Dame, where she had done her law degree. And then they helped get her the circuit court job. And so she was sitting there ready for RBG to die. And as soon as RBG died, that was their whole plan all along. They slid her into position and they took advantage of it. It was their long game all along. So she's been groomed for this. And this is a network of people who were funded by all kinds of dark money. It's a lot of corporate money. We don't really know where it comes from, but it's people like the Koch brothers, and they're pouring hundreds of millions of dollars into these nonprofits that then support the Federalist Society and their appointments, because they want to have their far right-wing corporate-friendly people in place so that when things come in front of the Supreme Court that are going to impact their corporations, they have somebody who's ready-made and kind of owes them and will give them a favor. And especially, if you're a female or a minority and, you basically sell your soul to the GOP in exchange for some power, you better do what they tell you, So she knows that she was hired to do this, and she will do what they want. She'll be their mission girl. So that's who she is.
The handmaid.
And also,
okay. Yeah, good. Sorry.
And also, like, if you've noticed, the Supreme Court is 2/3 Catholic right now. So that's, again, the Federalist Society at work. So America is not 2/3 Catholic, but the Federalist Society has been kind of working in the shadows for all these years, picking out Catholics and, as they go through their training, getting them all the credentials that they need, sliding them into place. And then when the moment is available, then they put them in position. And everyone thinks the evangelicals are the far right in this country, but there's a lot of conservative Catholics that are kind of a problem too in this country. Not Sonia Sotomayor, she's a progressive Catholic, but the rest of them on the Supreme Court, they're conservative Catholics, and they are here to enact the right-wing agenda. And so they're coming for everything you think they're coming for. I mean, there's no question. All of them have been groomed by the Federalist Society. They're all members, Kavanaugh, Alito, Thomas, they've all been members of the Federalist Society. So we know what their agenda is.
Okay, let's kind of unpack some of those statements. I mean, it seems like, based on what Sandy's saying, there's like this Catholic cabal to get a bunch of Catholic, what would otherwise be, people going into the ministry. Well, no, we're going to steer you into judicial career. I don't think that's the case. Just like I don't think it's a coincidence. I mean, I don't think it's by design that I think something like 5 out of the 9 justices at one point were from New York City. It's not like there's a New York City cabal that wanted to have every borough represented. I think it's just maybe their backgrounds, maybe the type of education they got, maybe their legal experience. Now, Federalist Society is, I think, very active. I mean, there's no doubt about that. But again, I don't think they're doing anything illegal. It's not like they are.
No, it's not illegal.
Right. So, I mean, I guess the argument begs, well, why can't left-leaning groups organize?
Right.
And
right. We need to do that now.
so it's fair game, isn't it? So, I mean, why don't they then look for, progressive practitioners, let's say, coming out of ACLU, or other, elite law schools and groom them to be in the mold of Justice Ginsburg and Thurgood Marshall. So it seems like what the Federalist Society is doing is they're just in it for the long haul. They know that the demographics are changing. They know that eventually, because of the demographic change, the country is moving further to the left on social issues. So the only roadblock to that drastic change is to have the court system to be checks and balances, which is perfectly permissible under a constitution. So I could see why you would object to it, but I'm just not sure if it's, completely like this kind of, premeditated design. Also, on Justice Barrett's judicial philosophy, I'm just not sure if she is as pro corporate interest or pro big business as others. Like John Roberts is very clear. He even said, Citizens United and all these other cases, it's pretty clear where he stands. But I think somebody like Justice Barrett, number one, she doesn't have like a lengthy record to go by. And number two, we're going to go into a record in a moment here, but a lot of it is on issues like reproductive rights, gun rights, criminal justice, that sort of nature. But you can make an argument that because she comes from the Seventh Circuit, which is very conservative. I mean, that's the circuit where Justice Posner and Easterbrook all hail from. And that is probably one of the most, I hate to use the word libertarian, but it's a very kind of free market, University of Chicago style jurisprudence comes out of that district, or that circuit rather. So I think you could certainly make that argument. Okay, let's go further into Justice Barrett's background and judicial philosophy. So let's hear from Lorraine, then Earl.
Sorry. Yeah, I'm sorry. I just wanted to make a comment about what had just been said, if you don't mind. I don't think that we should attach a negative attributes to planning, which is, even if it's long-term planning, and I think Thomas covered some of what I was going to say anyway, but corporations don't just find a CEO leaves and they all just, throw their hands up and wonder what are they going to do. They have a whole succession planning in place with candidates being groomed for possibly taking over. So it's an aberration that you aren't planning, in my opinion, not that you are planning. Whether or not you want to see it that way is up to you, but I don't think that that's a negative thing to plan. And the other thing I was going to say was that since judges are a key part of the president's job to nominate, I believe that Obama was very remiss in leaving a lot of appointments open, not the Supreme Court, but obviously. But interestingly enough, I believe he also asked Ruth Bader Ginsburg to resign while he was president so that he might be able to replace her, because she did have a poor health record. And I guess she declined to do that. But, obviously he would have been in a stronger position if she had done that.
May I ask a clarifying question?
Oh, sorry, Annette, you want to ask me?
Just to clarify, if he asked her to resign at a point in time before Merrick Garland or after Merrick Garland was nominated?
I don't know the timing.
I mean, if it was after, then she would have had evidence that they're not going to replace her if she resigns.
Well, right? She had cancer about, I don't know, I would say 3 or 4 times. So
sure.
It didn't look great.
Yeah.
It wasn't just a question of asking her to move out of the way. I mean, she had some serious health issues. But no, I'm sorry, I can't tell you. I don't know the timing.
You don't remember the timing? Yeah. Okay. Thank you.
It was in 2013.
I was going to say, to Lorraine's point, she mentioned about and correct me if I'm wrong. Obama being remiss in leaving several appointments open. I do want to point out that is, again, not taking up for anyone, but that is the fault of Mitch McConnell. One of the big things that McConnell did was to not fill any of the vacancies during Obama's terms on purpose. This was not something that Obama just did not do. He would nominate people and they just wouldn't get their fair day in front of the Senate to be confirmed, which is why there were, I don't know the exact number. I do know that it is in the high hundreds, and it may even be into the 200s of positions that were not filled. And so if you look back, for example, over the last 3.5, 4 years of the Senate, you'll see a lot of judicial confirmations, especially to the federal bench, which were positions that were purposely left open by the Republican-controlled Senate, led by Mitch McConnell, for this very reason. So what they did on the Supreme Court is not surprising, especially when you figure out what they did on the federal bench, but it is still abhorrent. Sorry, I just wanted to.
No, Tara, I'm going to say something you don't hear in discussion groups very often. I didn't know that. Thank you for correcting me.
Listen, these podcasts these days are very, very informative. And so I've been listening to a whole bunch, and especially from people that are in the legal profession, like Thomas and others. So.
Okay.
Just a point about Justice Ginsburg. There was this famous White House lunch where then President Obama invited Justice Ginsburg in 2013 because he knew that the writings were on the wall and he was going to lose the midterm elections of 2014 because I guess part of it was kind of the backlash to Obamacare. So in anticipation of Mitch McConnell coming in, I think then President Obama addressed that issue with Justice Ginsburg. But I think at that point, Ginsburg felt that, well, I'm here, might as well just kind of ride out the storm and see what happens. And we know what the rest of the history is. Okay, let's go to some other members. Let's see, Earl, then Kalin.
I provided a link to the group, which is a summary of a report that I did on originalism. And it was requested by a bipartisan group in terms of what my analysis of originalism really is. And you can read the summary. A lot of the classified stuff is set out, but the public material is there. Originalism is what I call a Trojan horse. It's a bright and shiny object to get people to talk about something that doesn't really matter in terms of the overall strategic plan. I provided a link to a memo which was written by Lewis Powell, and you remember Lewis Powell because he became a justice of the Supreme Court, and he laid out in that memo a strategy for remaking the legal profession and then subsequently the judiciary along essentially ultra right-wing lines. So that process begins in 71. And virtually every right-wing scholar and legislator that I talk to has a copy of that memo in their desk. It's the battle plan that the alt-right has been following. Then a guy named Horowitz comes along and he picks up the Powell memo and gets funded by a number of right-wing extreme organizations and begins putting forward this idea that if you could simply pack the judiciary with like-minded judges, you could then protect the interests of the wealthy and the corporate interests. And so Horowitz's clientele, Michael's clientele, was essentially the same clientele that John C. Calhoun had, which in his case, it was the Southern planters. And so Bork, who was mentioned here, comes along, and he is the originator of the idea of originalism. And what's interesting about Bork is that he realizes you need a bright and shiny object to get everybody to chase it down the road and not pay attention to what is actually going on. He was one of the prime movers in the early Federalist Society groupings. And one of his replacements, the guy that he actually got into the Supreme Court, Scalia, was the advisor to the society from Chicago. So if you looked at this, and you can read what is there, I mean, I make some analysis on abortion and gun rights, looking at the Second Amendment, looking at the 14th Amendment. Much like the discussion we've been having about McConnell, this discussion about ethics and politics is just a bright and shiny object. It's power politics straight and forward. And if you look at Judge Barrett essentially is been groomed. I mean, she clerked for Alito. She has been groomed to be an advancer of the strategic plan in the Powell memo. So what's interesting about this is that people will go on and on about originalism, as if it's some sort of science or mystical technique to perceive what was in the minds of the founders when they wrote the Constitution. What's interesting about it is, if you look at the originalist interpretation of the Constitution, they look at it the same way as Protestants look at the Bible. It is a sacred text, immutable and unchangeable. But the sad joke is that when you get yourself in front of an evangelical and ask him to show the Bible as the King James Version, which is a bastardized version of the original Bible, that was actually written in Alexandria, Egypt. And when you talk to originalists about their interpretation, what you find is that all the originalists are right-wingers whose objective is to protect the property interests of the wealthy and the corporations. And they bend the words of the founders to fit their agenda. And Barrett is no different than any of those guys. Barrett was selected because she's not that bright. Just like Kavanaugh, she's malleable. And somebody mentioned it, she's bought and paid for. And the overall objective is to craft a court which will completely ignore the majority interest of the American people on questions like abortion rights and healthcare and gun control, where the American people regularly poll in the high 70s in terms of what they want. And the Federalist Society and Horowitz and Bork and Scalia have crafted a court which is capable of giving the sign of happy motoring to the American people. Essentially saying, you all go to hell, we're on it for life, and what we decide determines your life. And that's, it seemed to me, what people are missing. When you get into a discussion about Judge Barrett, you get suckered into this originalist argument, and it is nothing but a distraction. Sorry to go on and on, Thomas, but I mean, I've spent untold hours putting together that report.
Yeah, thanks, Earl. I just posted a link to your analysis, and I see what you mean by how sometimes those who give too much deference to the doctrine of originalism treats it like a, this kind of holy gospel almost, nothing but sacred truth. So I do understand that point, but I'm not really that convinced that somebody like Justice Barrett has been bought by this big corporate interest or the evangelical interest. Because I could tell you personally, I have studied under constitutional professors who have a very genuine, deep-rooted philosophy on the idea that judges should not be policymakers. And judges are sometimes very bad policymakers because you don't want their personal opinions to infiltrate into their decisions. Now, we're all human beings, so of course there's going to be some kind of a personal influence that plays into the overall outcome. But there are many scholars out there who do believe in judicial restraint. And, I'm not sure if they necessarily cite originalism. I know that's something that Justice Scalia kind of, brought into the main dialogue, but they will cite cases like, the first real Supreme Court case, Marbury versus Madison, that's Justice John Marshall. Basically, the idea is, certain things are justiciable, meaning it's reviewable by court, but then from that point on, there were a whole series of cases where the court said, if an issue involves, quote, political question, they toss it out because it's not their job to decide whether if Obamacare is constitutional or not, because sometimes these things are beyond just the scope of a judicial review. You can make an argument that the court has become very activist, and it's been activist on both sides. I know conservatives like to pretend that the conservative wing is always judicially restrained, but no, you look at decisions like Bush v. Gore, Citizens United, go down the list, the Janus case involving trying to break up federal unions. I mean, they have been very activist. And of course, the left has been also active as well. It just, if the opinions agree with your personal views, that you tend to kind of put them on this, pedestal, as like these kind of heroes, if you will, because you like the outcome. But I think the ultimate reality, and this was going to be my conclusion for tonight, but I'll bring it up now. I think these justices, while their jobs were meant to just call balls and strikes, because we have a failure, like a gridlock in Congress, then these cases get tossed to the Supreme Court to decide. And there are a handful of cases like that. The census case was certainly like that. So was the travel ban case under Trump era. And then also some of these cases are inherently political because it involves things like gerrymandering and redistricting. So I think the court has become a lot more politicized because of that, but I'm just not sure if it's directly by design. Like there's somehow like these, special interest group gathering behind the cloakroom in the Senate, trying to find a way to control how these justices will rule on these cases. I do agree with Earl that there are some real issues with originalism, because I think a lot of conservatives like to kind of cherry pick only the aspect of originalism they agree with. But if you look at the entire Supreme Court jurisprudence, I mean, probably one of the worst cases are things like Dred Scott and Plessy v. Ferguson. I mean, you ask any legal scholar, and those cases are just universally rebuked. No one's going to ever cite those cases in their legal briefs. And yes, Korematsu is another case that's universally rebuked. I think that one just got repealed just recently. Overturned just recently. But a lot of the originalist ideas were used during Plessy v. Ferguson, because back then they thought the framers thought it was okay to discriminate based on race. And when they tried to understand the mindset of the framers of the Constitution, well, they thought that was perfectly sound reasoning. It turns out it's not. So there are some dangers to kind of strictly adhering to the originalist thought, because it really could end up in a pitfall, judicial pitfall. All right, let's go to some other members. So Kalin and then Pedro.
Thank you, Tom, and thank you, Earl. I will say after you, I mean, I acknowledge that you have said both said interesting and very deep stuff about originalism, but I think we have not specifically discussed at least the public position of originalism, which is to put the Constitution, again, as Earl pointed, in a sacred place that have to be interpreted only in the way that founders understood it. And this definitely is opening the door for personal interpretation, despite the fact that they claim that in that case, they actually stay away from involving their personal opinions and personal political agenda, if I may say, in this. So they say Constitution shouldn't be understood in any other way than the founders understood it. If the argument about the society is changing, so the laws should reflect the new society, they counter with the argument that well, Constitution is the same, but the legislation that is built over the Constitution should address these changes in time. However, the Constitution shouldn't be changed in any way as an understanding. Well, it obviously Constitution is written far distant in time, so definitely not address all situations that arise in our current situation as a society at all. And in that case, you have to decide, have to extrapolate the meaning of the Constitution as it is as a values. And here I guess I tend to agree with Earl in that sense that that particular argument and argumentation is going to support a particular position instead of really searching for the meaning, because when we speak about values for unjust and unusual punishment, as the way that punishment can take place can change. However, the value itself seems quite clear. So if they close the door of interpretation of unusual punishment and unusual and unjustified, cruel and unjustified punishment in a way that our current society understands it, then they they do not make like a constitutional problem a big portion of the things that are happening now. And in that way, it is very limited and narrow view of the things. And Amy Barrett is, she is fully into this. She is very much promoting the concept of originalism. She is giving lectures explaining the content of originalism in a much better way than me, because she, after all, is too accustomed and she's a professor. I mean, she's much more knowledgeable for sure. But the basic argument that he's providing seems like this, what I have tried to convey to you. And in that way, how this could affect the further decisions, future decisions of the court, I believe we'll discuss later for sure, so probably I should not get there. But also talking about the Amy Barrett, apart from the originalism as a judicial philosophy, I would point another thing which was like in resonance of the more previous points that have been made about the Catholics in the Supreme Courts and etc. Sandy didn't mention the controversy of her being part of the closed society, Christian society. What was the, let me find it out, people of, what was the?
People of praise.
People of praise, that's correct. So this is kind of closed. They are supposed to support each other. It's kind of not a lot of publicity and transparency are shined. So this question also is how much this could influence her decisions is an open question, and it was arisen when she was nominated for the Seventh Circle. So with this, I will close my talking for this particular point. Thank you.
Thomas, I just wanted to make one example of what the subtextual strategies are of these originalists. Roe v. Wade was decided based upon the due process clause of the 14th Amendment. Abortion was not an issue. The issue is a right to privacy. If you get originalists drunk enough, they will tell you they do not believe that there is any right of privacy that any American has that cannot be overturned by law, not by an amendment to the Constitution. Robert Bork argued that the Bill of Rights was inappropriate and wrong, and that the Constitution did not provide for freedom of speech. I mean, he's made this argument many, many times in his early years. He believed that there was no inherent freedom of speech. They're not talking about just overturning abortion. If the Supreme Court overturns Roe v. Wade, they have pierced the issue of whether an individual has a right to privacy. Period, paragraph. It's not the victory on abortion. The evangelicals are just useful idiots in this. They are clearing the way so that the government can interpenetrate any part of an individual's life and essentially neuter the due process clause of the 14th Amendment. Sorry to jump in, but I mean, there's some really serious stuff going on here, and Barrett is there because she's part of the army that's advancing this towards these objectives.
All right, just two comments, and then we'll move on to Pedro. I know you've been waiting. One is, I think when it comes to separation of church and state, in the recent cases, they have been pretty robust in a sense that they do uphold the precedents when it comes to that. I think it's just in the recent years, ever since like 2015, when the same-sex marriage case was handed down, that being the Obergefell case, now there's the threat of religious liberty. So now the religious, I guess the evangelicals, at one point they wanted to exert their influence to the bench. Now they're being the victim, saying that, well, my right to exercise religion has been hindered by same-sex marriage because I'm forced to, let's say bake a cake or participate in some kind of ceremony or others. So I think now the table has flipped. So I think you might see this kind of a rise of more sway by the evangelicals and the court's overreach to protect their rights. We saw that case with the Catholic nuns in Montana in the last term, and there's going to be other cases like that. But just going back to the other point about abortion, I'm sure this will come up tonight because there's one area of law where Justice Barrett has pretty clear track record, and her statements too. I believe sometime in 2005 or 2006, she signed off on an ad. I'm not sure exactly how she signed off, but she either endorsed it or her name was attached to it as a faculty member of her law school, where she basically said, abortion is like a savage-like act. And also there were some cases as when she was the Seventh Circuit judge saying that, there should be more like a full hearing of cases on abortion instead of just trying to dismiss it summarily, either up or down. And then, of course, you cannot ignore her faith, which obviously plays a very big role. I think her choice to go to Notre Dame Law School is certainly no accident. She's a very kind of like a proud Catholic, if you will. I know someone else already mentioned that. So it really begs the question: what's the future of reproductive rights? And for those of you who tuned in during the nomination hearings, what to me the takeaway is she followed the Ruth Bader Ginsburg rule, which is don't answer hypotheticals, which is perfectly fine. All justices do that. But there are some cases where she called it a, quote, super precedent. So I believe, I'm not sure which senator it was. It might have been Klobuchar from Minnesota. I think she asked Judge Barrett, well, do you think Brown v. Board of Education was correctly decided? And without any hesitation, Justice Barrett said, yes, unequivocally, that's the right decision, and that is a super precedence. But then later on, I'm not sure if it was Blumenthal or somebody else asked, well, what about all these other reproductive rights cases, starting from Griswold versus Connecticut? That's the case that allowed contraceptives to be used without any government prohibition. And she kind of did one of those, well, on one hand, this, but on the other hand, maybe it's so well established. And I think what that telegraphs is that that case is up for debate. And if that case is up for debate, then that goes to the heart of reproductive rights cases. And what's interesting is when they asked her about Roe v. Wade, again, asking her, was that case decided the right way? Instead of saying either A, there was a super precedent, B, it was a precedent, or C, sometimes you'll hear justices saying that it's a well-settled law. Let's leave it at that. She didn't answer. And she, in fact, cited Planned Parenthood versus Casey, which is a later case that came out in 91 or 92. And that kind of restricted certain the rights to abortion from Roe v. Wade. So for her to not answer Roe v. Wade, but then answer Planned Parenthood versus Casey, I think that kind of telegraphs what her judicial philosophy is on this issue. So I don't really know what to expect other than just based on her record plus her responses. I think it's pretty safe to say that if an issue came up, like the one that we saw in this term I believe it was in the state of Louisiana, where Justice Roberts played a swing vote in repealing the Louisiana law that was identical to the Texas law from a few years ago that restricted certain rights to reproductive services. I think Justice Barrett will be glad to join the conservative side. And one other point, sorry, this is too much Supreme Court inside baseball, but I think if that's the case, I think Justice Roberts will gladly join the conservative side now, because he no longer has to give off this appearance of institutional conservatism. He's a cultural conservative. The only reason why he's an institutional conservative is because he's trying to avoid these 5-4 decisions. But now the court is a solid conservative bloc. I think all bets are off. So that's my analysis. Sorry for going on too long. Pedro and then Caleb.
Okay, well, for starters, I'm actually really enjoying the group. I think I got really lucky getting here. But I have a few things going a little bit further back. First, Sandy, I'm a practicing Catholic. Sorry, everybody. But I just want to say that Catholicism is pretty divided as far as liberals and conservatives are concerned. It's about a 50-50 split if you really look into it. I actually dated a Catholic who was very conservative. I was very liberal. We didn't last very long. But it is about a 50-50 split as far as Catholicism is concerned.
Yeah, true. That's why Sotomayor is a progressive Catholic, and she doesn't vote the way that the others vote. So, but they're looking for the far right conservative Catholics in the Federalist Society.
Oh, and I completely agree with you there. So I did law school in the University of Houston in Texas. So it's an extremely conservative law school. Thomas, honestly, I think we probably had the same professors I mentioned in the chat, but they were very, very originalist. They were the Constitution is how it was written. You should interpret it as it was written. And as opposed to the living constitutional theory where you just kind of change it according to the circumstances, or which is, it's kind of a ridiculous position, and it's very seductive in its way, because you look at the Constitution, it was written, let's say they passed an amendment in I don't know, 1850 about a 2-horse carriage. And then you're interpreting that law in the 1950s with a car. Well, how could they foresee a car when they wrote it in the 1950s? So we shouldn't try to look back into that period. But at the same time, you write a law in the 1950s about maybe a 2-horse carriage, and then all of a sudden you have to interpret it because they add another horse to it. And then, I mean, even then you're already interpreting it based on something you didn't anticipate. Or maybe they created a new wheel to the carriage and you have to interpret. I mean, the law just changes because otherwise you have to pass a law every week because the situations change according to the laws. Going back to the point of the Federalist Society, it is a grooming mechanism. I was actually approached by the Federalist Society while I was in law school. I think I would have been, it is the organization that you join in law school as the first step down your path towards conservative success. Down a political path in that arena, whether you want a court appointment or whether you want a political position or you want to run for office, you're constantly being tested for purity. What the first step for a lawyer is to join the Federalist Society and maybe publish something conservative before you graduate, and just kind of continue to keep that track record of solid conservatism. The reason being, special interest groups want to donate money to a sure thing. They look at your positions over time, and they see, okay, he was in the Federalist Society. Oh, he's been writing about conservative issues. Okay, we can trust this guy. He's not going to change his position. He's going to vote according to our corporate interests. Let's donate to his campaign. Let's donate to his vetting for a federal nomination. Let's make sure that he makes it to the federal bench in the right circuit. So when the time comes, he's appointed as Supreme Court Justice should the opportunity arise. A good way to know is whether they were appointed to the DC circuit. Honestly, anybody appointed there usually has a frontline seat to the next appointment in the Supreme Court because they're so close to Washington. They can really schmooze with the senators and get really good access. But it's a purity test. You just kind of keep going at it. Democrats don't have this similar system. I almost wish they would. The Republicans have a very well-established system, and they're very, very, very united in it. Democrats lack a lot of unity. I'm a Democrat. I don't want to. I'm not talking outside, but I wish our party was a little bit more centralized, a little bit more structured. So that, I mean, I don't want to become a Republican Party. I don't want purity tests, and I don't want all of this system to basically copy the Republican Party. I did like the whole task of, oh, when they go low, we go high. I wish it was an ideal that we could stick to, but the other parties made it almost impossible to stick to it. We're playing this game of constantly escalating matters that we just kind of have to meet fire with fire almost. But I did have one last I think thing I wanted to mention. Oh, originalism. Wait, I think I already mentioned that. And better laws. Okay, so we're dealing right now with what will be a new era in the Supreme Court. I mean, courts are defined by eras. Usually, I mean, they're defined by the name of the current Chief Justice. Like right now, we're in the Roberts Court. And we're basically stuck in the Roberts Court for the foreseeable future, probably for the next 20 years. And every law that's going to be passed from now until I don't know, another justice passes away and we get a new appointment is going to be very conservative. The only thing I could advise for policymakers is we need to get the majority in both houses, and the laws that we write have to be very solid. It's the only solution. I don't believe the solution is going to be to pack the court. Because it'll come to haunt us later. And I still believe in the principles of going high rather than going low. But we need more outreach. We need this to motivate us, and we need more voting, and we need a full both houses. And the laws have to be perfect. One of the things that disappointed me with the Affordable Care Act was how it was passed. It was a shame. It was Senator Kennedy died right when the law was passed, and they couldn't change it. President Obama was forced to pass an incomplete law, which kind of had a lot of holes in it. Honestly, I did publish a bit of a constitutional argument because I did find a hole in the Affordable Care Act that I just kind of saw. It was my publication before I graduated law school. Hopefully nobody ever reads it. It was a student note. I don't think I really will. But that law had a lot of flaws because of the way it was passed. When Senator Kennedy died, they lost the Senate majority, and all of a sudden there was no way to change it. We need a solid majority in both houses, and the laws have to be perfect. That's all I could advise as far as going into the future, because the future will be the next 20 years, and our only defense right now is to hold out with something that doesn't take 20 years to do, which is to vote in the midterms. And that's my comment.
Okay, thanks, Pedro. I guess we'll also bring up the Affordable Care Act, since that was mentioned. I did post a link to the law review article that then Judge Barrett had authored back in 2017. And the title of the article is called "Countering a Majoritarian Difficulty." And there, she's talking about this kind of like the dangers or the risk when there's too much access of democratic process. And in the end, she concludes in the last page, basically, the Supreme Court rewrote the law because the law didn't maybe pass the constitutional muster. Then Justice Roberts came in and he called it a tax instead of calling it what it is, which is the penalties under individual mandate. So, maybe that is kind of in conformance with her originalist idea. But the key question came down to, there's another Affordable Care Act challenge that's on the docket right now for the Supreme Court term. And is she going to recuse herself? And of course, she didn't answer, which is fine. But you have to wonder, is she going to have that neutral objectivity and approach that case with an open mind? I think the answer is pretty clear by reading that law review article. All right, let's go to Caleb and Andrew.
All right, so I'm going to preface this as someone who looks at things like naively. I don't know much about constitutional law, but I find like both perspectives a little bit weird. On the one hand, you see the Constitution as a living document, which to me just sounds like it can be whatever I want it to mean. according to the situation. Like you use the words to help you justify whatever decision to make, but because it's a living document, you know, those words can mean different things and you can get different outcomes from however way you interpret it. On the other hand, you have those, like you guys mentioned, like you all have mentioned, thinking of the Constitution as like a firm thing. This is what it is, you know, you follow it to the letter of the law, and you know, you're trying to be as precise as possible, like almost making it like a mathematical equation, A plus B equals whatever. So, so for me, I find both views kind of radical, and I think to some degree the founders understood that, because they did give a way for the Constitution to be changed. The only problem is they made it so difficult, and purposely difficult, but I think maybe too difficult, that they had high expectations, I guess, for bipartisanship and, you know, agreeing in terms of like how to change the Constitution and whatnot. And I think what Thomas said exactly as his final conclusion is correct, because at the end of the day, it's the failures of the legislative body. If there are laws, or if the Constitution is flawed in certain ways, ideally the right way to change that is to change the Constitution, or change, you know, through amendments or whatnot. I don't know what the correct terms are in this scenario, but the idea is you change it, and that's the role of the legislative body. And the legislative body has not managed to do anything in terms of that direction, because they just don't have enough bipartisan consensus on these issues. So what happens now is that the Supreme Court has all the power, has all the pressure to take the laws and the documents that are hundreds of years old, and kind of make decisions that make sense in the modern day, because it's kind of like they're given the content, they're given the laws, they're not the ones deciding the laws, they're just there to interpret it, so to speak. So, you know, I think it's all just because of the failure of the legislative body, and now the Supreme Court is not the Supreme Court, really. It's not there to really just decide cases. I think it's there to also make it. I think everyone can agree that like the judicial body now is just acting as a like supplemental to the legislative body and passing laws on their own, so to speak.
Yeah, that's a good point. Before we get to Andrew, I'll just mention one other thing. There's always like this tussle between the originalists, and you also have some of these like textualists and the strict constructionists on one side, and then the other side would be somebody like Justice Ginsburg, who thought the Constitution was more of a living, breathing document. And Justice Ginsburg interpretation is, well, you know, the framers had this notion of the perfect union, and the history of the U.S. has always been kind of enlarging that circle of rights that people are entitled to by building a bigger tent and trying to get to the level of as perfect as union as you could get. It'll never be 100% perfect, but you're trying to achieve that perfection step by step through different branches of the government. That's kind of Justice Ginsburg's overall view of the government. The originalist, just if I could summarize it in the quickest brief manner, it'll be that it's a product of the Enlightenment era. And if you look at the framers, their number one concern was tyranny, because they knew how tyrannical these kings were back in England, and they wanted to get away from monarchy. And if you look at all the rights that those thinkers from the Enlightenment era, the philosophers were thinking, were individual rights. And what were the individual rights? Well, the right to think, speak, associate, etc. Right to defend yourself, right to live in a state that's free of overt state-sponsored religion. So the question then becomes, as we sit here today, October 2020, are we still living in the same time period where the issues at play, the forces of threats, are they similar to the Enlightenment era? I think you could say in some sense, yes. But in other sense, we live in such a complex world that even just the simple advent of technology has put us far greater in a complex society than the framers did. So it's a very complex matter. And I hate to play this kind of, on one hand this, on the other hand that, but I think there are some universal virtues of what came out of the Bill of Rights. But I'm just not so sure that everything is gospel. Like, for instance, I'll just give you one example. When was the last time you guys ever had a conversation on the Third Amendment? Nobody talks about the Third Amendment. You probably don't even know what a Third Amendment says. Basically says during a time of war, you are not required to provide shelter for soldiers. Again, that is the product of 1789 or sometime around there. We don't really have those issues right now. So I think a lot of these principles are kind of universal, but not everything is. And I think that is really the the give and take that you see on the Supreme Court. Okay, one more point from Andrew, and then we'll go into the breakout room. So Andrew, go ahead.
Oh, yeah, sorry, I came in late. I guess in terms with the Amy nominee, in terms of her, I don't really know much of her background. I guess my worrying issue with her is that she seems to have some kind of very strong religious background, as everyone said, and I think most people are worried that she might put her faith above the law, and I think that's one of the biggest issues I have in terms of with Amy. And also with the Federalist Society, I wanted to ask the question: was the Federalist Society, was that around for quite some time, or like who first funded that kind of society, or was this something that's pretty much around for quite some time, in terms of the Federalist Society?
Does anyone want to answer that, or I could jump in?
I can kind of. I mean, I don't know exactly when it was founded. I know it's right now. It's a law student kind of group. And I mean, it's kind of like a part of a Republican kind of think tank, but I don't know when it was founded. I didn't join, so I don't know much about it other than that. Maybe Thomas, maybe you know more about it.
It was founded in 1982.
Yeah, that sounds about right. So in the early
time of Reagan too.
Yeah, I mean that timeline certainly syncs with the Reagan era. But just to take a step back, I think it was kind of in response to the civil rights. Not that the Federalist Society is against civil rights. No, I think it's a lot more complex than that. But they saw what the ACLU, the likes of Thurgood Marshall and others, even Justice Ginsburg, before she became a judge, she was very active as a ACLU litigator. They saw what they did, organizing and mobilizing people to petition change, and they sort of follow that model. Again, they have a whole different agenda because their agenda is more kind of free market, very strict construction of the Constitution, originalism, etc. But it kind of started the movement in the early 70s. There was a guy by the name of Buchanan, not Pat Buchanan, but that's another Buchanan. I forget his first name, but he basically kind of wrote this, doctrine or manifesto, if you will, saying that, hey, it's good to have, big businesses get tax cuts and deregulate because, they were kind of the early proponents of trickle-down economics. So you couple that with Justice Lewis Powell, who Earl had mentioned earlier, who was not very conservative, but certainly right of center. So you had a lot of these justices coming to the ranks in the early 70s. And by the 1980s, I guess that's when the Federalist Society started. They certainly rose up to the ranks where now you had a very conservative administration appointing conservative judges to all different federal bench. And then the Supreme Court got pretty conservative too, because that's the Rehnquist era. So it's a combination of various factors at play. I still don't think it's like a very concerted effort with the Koch brothers sitting around a conference room, just pressing buttons, trying to see who's going to block it, March steps. it could certainly well be that they might end up doing exactly what they want in terms of deregulation and siding with corporations like Citizens United. But I think it's a lot more complex, and especially when you put in these like social issues into the mix, like same-sex marriage, abortion, even transgender. I mean, that issue got litigated during this term, this past Supreme Court term. So it's a very complex matter. I don't think it's simply like binary, one side versus the other. There's multifaceted issues at play. So I see a hand up from Sandy, and after that, we will go into the breakout room where we'll talk about this notion of packing the court. So Sandy, go ahead.
Yeah. So I've heard with the Federalist Society that they really decided to work in a very concerted way after Bork didn't get nominated to the Supreme Court, because he was a very controversial figure and his far right views were very obvious, and he was also kind of a loud personality type. And so they kind of realized, if we want to advance our agenda, we need to get people moving into position, and they need to have a really clean record. They need to keep their head down, not make waves along the way, not draw attention to themselves. They just want people who were quiet, put their head down, and worked towards their agenda. So from what I've heard, like the Bork situation was what really led to them to really try to make a concerted effort to get people who were sympathetic to their agenda in line for court positions.
Yeah, I think that's right. And just in looking back in retrospect, I'm just not sure how radical Robert Bork would have been if he got nominated to the bench. I know he's very pro-life. That is well established. But other than his pro-life position, I'm just not sure how radical he would have been compared to, let's say, Clarence Thomas. I think he might have been in the mold of Clarence Thomas. So then the question is, well, is Justice Thomas very radical? Well, I think conservatives will say no. He represents our mainstream conservative values. So again, that's kind of very, debatable. Okay, let's go to Annat. Then we'll go into the breakout room.
Just to clarify, I had this idea in my mind that the reason Bork was so controversial was because of his role under Nixon, and not, I mean, sure, maybe he was very conservative, etc. But I thought that was what the big deal was. Sort of in the same way that you had this issue with Clarence Thomas and Kavanaugh. So, I mean, is that wrong?
Yeah, I think Dave just answered the question. Dave, you want to expand on that a little bit further in terms of his paper trail?
Yeah, the problem with some of the nominees, and Bork was a good example of this, he'd written a lot. He'd written a lot of opinions. It wasn't necessarily, I think, in all cases, his viewpoint. I think sometimes he just liked to argue. And I think he'd write a paper on a particular approach to the law. And of course, this all gets dug up. And the people that, Souter's the best example of somebody that was a stealth. Nobody knew because the guy never wrote anything. So that became a kind of a safe thing, is, try to find somebody that doesn't write as much. Barrett and Breyer have written more. And so that just makes it easier to make an assessment of where their heart might be. So that's it.
Yeah, I think that's right. I think Robert Bork would have been, I don't know if you guys remember Christopher Hitchens. On some issues he was kind of conservative, but then other issues he was more like not conservative. My recollection of Bork was somebody like him with a law degree and with a judicial background. And he, like Dave said, he was an intellectual. So he would write about everything. And I'm sure there came a time when somebody said, hey, can you publish a paper on reproductive rights? And he said, okay, this is what I think. And I think that really got scrutinized during the Supreme Court nomination process. And I think that really was the flashpoint where up until that point, as somebody has suggested, it used to be just a matter of rubber stamping. It's the sitting president's prerogative. And it's that moment on, I think it was Teddy Kennedy, probably Joe Biden too. They said, well, let's turn this into a theater. Again, for better or for worse. I don't know. I wasn't there, but it seems
Well, there actually were other modern presidents that had nominees that were rejected. Nixon, Johnson, and Eisenhower. But I think with Bork, I think you could take his writings and you could really play them as being ultra conservative. And nobody can beat Gregory Peck. I mean, I remember the radio commercials about saying, this was going to take us back many, many decades with all his conservatism and his sort of racism and so-called and being against civil rights. And I think he just liked to express his views. And it's true. One of the concerns about him was because he's so intellectual, because he's outspoken, he might convince a moderate to go even further to the right. So I think that's another reason.
Yeah, and I think another explanation too is by 82, these hearings were televised. I'm sure they were televised in the 70s too, but this became like a 3-day televised affair. So, it creates great TV moments. And, of course, when, little snippets get blown out of proportion.
And he wasn't good at being subtle. I mean, I think a lot of the, nominees, they say a little bit, they don't claim to have an opinion on certain things. Remember, Clarence Thomas never discussed Roe versus Wade, right? That's what he said, right? When he was during his hearings. So I think that Bork probably didn't answer the questions as creatively or as carefully as maybe he might have.
Okay, so there wasn't a question about like his ethics, like as
the Saturday Night Massacre. I don't think that was brought up a lot or was I don't think, I'm not saying it was a completely non-issue, but I don't think that was
not the main thing.
I don't think that was a big thing that was brought up.
Thanks.
Okay, so why don't we go into the breakout room for about 20 minutes. And again, the question is, do you support or oppose this notion of expanding the court? They call it the court packing. And for those of you who may not be familiar with it, this was brought up during the FDR era because in response to the Great Depression, there were a whole bunch of federal policies that FDR had enacted, and it got struck down at the court. So he wanted to have a court that would basically approve his policies. And he thought by strategically expanding the court, he would have judges that are more sympathetic to his policy. So in essence, it's kind of like, extra or super legislative powers given to these courts to rubber stamp the policy. So that's kind of the idea. And I'm sure that these ideas were tossed around back and forth, but now it has resurfaced. Some of you had mentioned about the presidential debates where both Biden and his running mate, Kamala Harris, were asked about court packing and they just didn't answer. And maybe that's just a strategic thing to do because by answering, that itself becomes like a news headline moment. So maybe it's better for them to not answer. I don't know. But
that's exactly what Joe Biden said. You're correct. He said, if I answer that question, that becomes the headline tomorrow, as opposed to the actual issues that are facing us right at this moment. He said that at the first debate, I believe.
Right.
Actually, I saw something.
Yeah, the most recent, he made a statement, so please, if you.
Yeah, I saw something last week. I don't know if it's the latest, but he had said he would get a bipartisan group together that would try to assess the situation with the court. So I know there's all this concern about how, it's just going to lead to an arms race, but that doesn't sound like that's what Biden plans to do. It sounds like he wants to be fair. So.
Yeah,
to be honest,
I'm sorry.
I just think they're keeping it in their back pockets. I think they're calculating the political points, like this, if I do this, will I get how much will I win? If I don't do this, how bad is the backlash going to be? I think they're just calculating politically which one is most beneficial as a decision. I think there's already so many people in their base that found them so weak, found Democrats weak, because they didn't do much during the Garland case, the Garland nomination. So now they're thinking, should we now act powerful, or are we overdoing it? Or, I think it's just a political calculation that they still haven't decided. And they're just waiting for, time to go by until they need to make that decision. And then, the circumstances will be more clearer and they'll know whether they want to do it or not. I don't really think this is just like a principle thing. Like, I'm very cynical. I think all politicians are just playing power games, and I've I feel like by listening to them and seeing how they act throughout years, that I'm correct in that everyone's just playing a power game. So saying like, I don't trust his excuse, and
Okay. Okay, really, really quick. If Biden says that he's going to pack the court, all of a sudden Republicans have motivation, they have a rallying cry, they start going crazy and they show up for Trump. If on the other side, the other side says, oh, we're going to pack the court, all of a sudden the Democrats get up and they start, going crazy and vote. So neither side wants that. So neither side's going to say anything. Okay.
Or there are just a lot more other issues that are more pressing than the Supreme Court. There could be that. I mean, it's not like, Democrats really sit there and say, "Ooh, we're going to get the power of the Supreme Court. Let's come up with like different ways to gain more power." That's not how they operate. I mean, I'm not saying that they don't think about keeping power when they do gain power, but at the same time, they're just not. They don't make long game strategies like that. So I don't know. I feel like him saying that, not giving an answer is completely human to me, because if I was in that situation, it's not something I'm considering. It's not something I can do right away. What I need to do is worry about coronavirus. What I need to do is worry about the economy. Why am I focusing on the Supreme Court right now?
Okay, why don't we pause it there? We'll go into the breakout room and then we'll come back in about 15 or 20 minutes. So the groups will be assigned randomly. So just one moment. Okay, we are back. So did you have a chance to discuss the pros and cons of expanding the court? So let's hear some ideas. Let's hear ideas in favor of packing the court. Anyone?
Yeah, Sandy, I think Sandy can agree with me. Right now, it seems very much like we are under minority rule. And by that, I mean exactly that. We're under minority rule. And it seems as if, and can we stop using the term packing the court? Because it's expanding. It's either expanding or retracting the court. It's not packing. So I am definitely in favor of expanding the court because I'm tired of living under minority rule.
I second that, Tara. But I would also say that the Republicans wouldn't blink about doing it if the situation were reversed. For some reason or other, the Democrats always blink.
Respectability politics is their problem.
I mean, is that true? Because I think, didn't liberals have the majority at some point?
Are you asking about back when FDR wanted to add justices to the court? Is that what you're asking about?
I have no idea. I'm just asking, is there
I
is
guess
there
they are-
precedent
When
to say
liberals
that
had
they
the majority where?
I guess the Earl
Supreme
Warren Court was probably some sort of liberal majority, although you couldn't necessarily predict that it would be. I mean, Earl Warren was a Republican governor of California. Not known as a flaming liberal. It's also true that people change and provide surprises sometimes when they are in the Supreme Court. Our position, our little group, was not happy with the idea of expanding the court primarily. I mean, Lorraine did have a few words in favor of it, but for the most part, our preference would have been to eliminate lifetime appointments. And I had mentioned this notion that Stephen Carter, professor of law at Yale, suggested. He suggested a 9-year term with a justice being appointed every year. One justice being appointed every year. In other words, jiggering the terms. So one is appointed every year. So it's not such a world war to get somebody appointed on the court, because you're always going to have a chance next year or the year after. I mean, the other notion is, maybe every 2 years. And also it was a popular idea that maybe the limitation of the term should be 18 years as opposed to either 9 or a lifetime.
Oh, I have a
I've
quick
heard people say
clarifying
that too.
question. Sorry, I just had this quick clarify. I think I heard somewhere, and I probably should go back and read this, but maybe someone here knows. I thought that I heard somewhere that there was like a soft limit, like it's not really, it's not really set in stone or anything like that, of like 20 years that they can retire, that they can stay on for like 20 years, and then then after 20 years they can retire if they want to, or something like that. Or
you can retire or resign at any time. What do you mean?
Yeah,
there was like something about 20 years in the Constitution for Supreme Court justices. You know what? I'm gonna go look it back up and come back to you. But
I've heard people say that 18 to 20 years is good because that's about the length of a generation. And if you think about it, if you look at the sort of the average ages of the current justices on the court, minus maybe the 2 newest justices, but you have Alito, Thomas, blanking on some of the other names, but we're talking about people in their 70s who are not even from they're not even from the generation right before like my generation. They're for sure
zombies.
baby boomers, right? They're very much on their and I don't mean to offend anybody here, definitely on their way out the door. And they're making decisions and interpreting laws for people that will be alive 15, 20, 30, some 40 years after they're gone. And sort of that they represent a bygone era as well.
I understand. Most of the justices actually happen to be middle-aged as opposed to elderly right now. Most of the, yeah, well, I'll just leave it at that. Most of the justices are 40s, 50s, and 60s.
I mean, that's the motivation with the lifetime appointment. The younger you can get them, the longer they stay in office. So I was in the Ralph group. We had two Ralphs, so I think we should call it the Ralph group. In any case, we did agree that the appointment shouldn't be lifetime. We just kind of disagreed on how long the single term should be. We don't want multiple terms because otherwise then we have justices campaigning for a second term, and that would defeat the impartiality that they're supposed to have. But I mean, you want a long enough term so that you still kind of maintain the integrity of the Supreme Court. There's a certain like goal for any attorney to kind of reach the Supreme Court. Even for me, I mean, I have no chance of it, but it's like you kind of want to be able to leave your mark on the world and on the legal community. Amber, like you mentioned, like some of these justices are really old, and they're setting opinions that are going to be there for decades after they die. But that's the motivation of it. It's their way of achieving history. It's their motivation to kind of leave their mark on the legal profession, on law textbooks that we all read. And you kind of want that. You want that motivation, that kind of purity in it. You want people to read your opinions and understand them and even sympathize with them. I disagree with Scalia on a lot of points, but he was a good writer. I'll admit that. I mean, I read so many of his dissents. He was a good writer. I disagree with a lot of the points he made. But as far as a legal scholar, he was decent. And that's all part of it. That's part of the mystique. And you want to keep that. You don't need a lifetime appointment. You want like a single large term, but you still want to keep that motivation, that purity of what the Supreme Court is supposed to be.
Okay, let's go to some other members. Ralph and Annat, what do you think?
Okay, thanks. Yeah, I think one of the disadvantages of the lifetime appointment, and we've seen this recently in particular, is they want to pick somebody young. If you can get a 40-year-old there, they can be on there for 40 or 50 years. And the motivation to pick somebody young is probably a bad idea. People should be picked for their qualifications and perhaps their views, but the idea that you really want to pick somebody who's young, I mean, that could go, pick somebody who's 30, they could be there for 60 years. So I think that would be a major basis for a major improvement for term limits.
Does anybody know what the minimum age is, just real quick? Is there a constitutional minimum age? I don't know.
No.
Nope.
It's only presidency.
So 18-year-olds, an 18-year-old liberal could be on there?
You would have to be somebody like Ben Shapiro, who graduated high school at a very early age and just went right to undergrad, skipped a few years and went right to law school. And by the time you become
but there are no legal restrictions, I believe.
Correct. Let's see. Andrew and then Annat.
Yeah, I just wanted to say back to the expanding of the courts. Expanding. Yeah. In terms of that subject, I don't think, especially in terms of now, it would be a very good idea to even do that in terms of where the Republicans are going and how they have their little factory of pretty much readied court justices up and going. I think it would be a very bad idea. I think everyone pretty much agrees or going on the point of trying to do some balancing with the courts, and I don't think in terms of trying to expanding it, especially now, it would really be a good thing to do, especially with how much the Republicans have the upper hand.
Okay, Annat?
I have two thoughts. The first is on the lifetime appointment. my feeling was that the lifetime appointment was the idea behind it was that you're not beholden to the person who nominates you, because you're going to be there through several administrations, and you know, they may change hands in terms of like the party that's in charge. So you know, I mean, I like the idea of not having it be a lifetime appointment, just so that we're not motivated to pick people who are younger and younger. But it, you know, it would be odd to say something like you have just like a 9-year term, because that basically means you're around only when the, you know, if let's say the person who nominates you is in office for 8 years or you know, then it could be that you have a very long overlap with that exact administration. So there's this opportunity for you wanting to, like, you know, give back in specifically in a way that benefits them. So it defeats the purpose of having the lifetime appointment in my mind. The other thing I'm not sure about is, so I don't know if I should bring this up, but it came up in our group, was less about, you know, whether or not you expand or retract the court, but about, we were talking about whether or not the federal court should be broken down into smaller jurisdictions, because right now they're fairly large. They span a few states each, and they're the court system is kind of overloaded. So I mean, the idea of there being that, you know, you'd end up with many, many more judges in the system if you did that. And that, I mean, yes, there are people who aren't picked to be in the Supreme Court, like from that, you know, from that system, but most of them are. So, yeah.
So, Annette,
I have a question. Maybe for the attorneys who practiced, or the, you know, those of you like Pedro, who's at law school.
I'm an attorney. I graduated 2 years ago. Sorry.
Sorry. Well, okay. So you're one of the attorneys who's practicing. Thank you. I do have a question. What exactly are the qualifications for being a justice? Because, for example, let's take Amy Barrett, since that's she's the main topic tonight. Only ever practiced for 2 years. Yes, she taught law for 15 years, but she also was only a justice for 3 years. And if I'm not mistaken, has never argued a case in front of an appellate judge or in an appellate court, but also, of course, not in front of the Supreme Court either. So I just think it's a little odd. But if somebody could, you know, expound on that, I would be eternally grateful.
So legally, there are really no qualifications. Anybody could be a justice. The only question I really had was about age, because I know, I mean, the presidency requires 35, but legally there really are no minimum qualifications. Anybody could be a justice. Your dentist could do it. The only qualifications are that it has to be nominated by the president, and it has to be added by consented to by the Senate. What's called presidential-wise, or as a former president, you want them to have some kind of a legal background. They all usually sit on a circuit court, which is the highest court outside of the Supreme Court, one of the 13 circuits. That's usually how it works. There have been other appointees. I know President Taft was appointed into the Supreme Court right after he ended his presidency. So it's not that they have to sit on a circuit court, but that's usually the norm. They start off as a circuit court judge, one of the 13 circuits, and then they get, when there's an opening, they get considered by the president, they get nominated by the president, and then they get confirmed by the Senate. But it's not a requirement. That's just what's been the norm.
Now, in the circuit court, is there any sort of precedent for them having a judicial background prior to their nomination to the circuit court?
I don't,
because again, she had zero judicial experience prior to being nominated to this. What is it? She's at the 7th Circuit, right? Zero.
I don't think so either.
So the federal judiciary, you do have to be a member in good standing of whatever state you live in, their bar association. So you can't just be any old, Joe Schmo off the street and now you want to be the judge. No, it doesn't work that way. You have to be a member of the bar. And in order to be a member of the bar, that means you don't have any like ethical issues like tax evasions or criminal offenses, that kind of thing. So it's
So then
obviously
how
somebody-
was Brett Kavanaugh able to go on? Because didn't he have like $2 million in gambling debt?
That
well,
might have
yeah,
gotten him disbarred, maybe, but when did that
Sure.
come out?
Yeah, but
Mr.
he was
Gam-
also being investigated by Justice Roberts, which, I mean, to me, that's like awkward if I'm investigating complaints against you and now you and I are peers.
Yeah, I'm not really sure about Kavanaugh. I know he had some personal debts, but again, is that a disqualifier? Probably not. I mean, look, lawyers and judges declare bankruptcy all the time, personal bankruptcy, that is. So I'm not sure that's a disqualifier. But overall, those are kind of like the floor requirements. Now, I think the question that Tara's asking is, well, Justice Barrett was only on the bench for, I don't know, since 2017, so like less than 3 years. Is that enough qualification? Well, apparently the Senate thought yes. There were other instances, but I remember in 2005, George W. Bush nominated his personal attorney, Harriet Miers, and she had zero experience on the bench. She was just George Bush's personal attorney. So that got struck down very fast. Then they wanted to nominate Alberto Gonzalez. That was his other personal lawyer, and that didn't go anywhere. So then they nominated John Roberts. One other example would be somebody had mentioned Earl Warren. I believe he was the governor of the state of California. Then he became the Supreme Court justice. So you do have some instances where someone holding a public office then sits on the bench.
But
So-
like he was holding a public office after, I mean, he was a member of the bar, like at the same time. I mean, it sounds like you have to be actually have have at least that to be nominated, right?
Right. Aren't because I know that senators cannot be practicing attorneys just like they cannot be practicing lawyers, but is that true for executive branch officials in the states and as well as the federal government? Because I don't think Obama couldn't be a practicing attorney while also being president, correct?
I don't know if member of the bar means that you're practicing.
Right. Just
Well,
means you're good standing, you're not disqualified. Just one
So it means
other
you
point,
passed
and
the
then-
bar and okay, got it. Now I understand the
One-
distinction.
Yeah, I guess one other point about the uniqueness of Justice Barrett is that up until this point, all the justices came out of the 2 or 3 top Ivy League law schools, that being Yale or Harvard. Justice Barrett comes out of Notre Dame, which again, it's a private school. It's a Catholic institution, and she's certainly proud of that. So I think in this regard, it kind of breaks the mold of this kind of Ivy League, duopoly on producing Supreme Court justices. So in some way, I guess you could look at that as, maybe that's a good sign that you have somebody who is from a, less kind of like this Ivy League, Ivy Towers type of mindset. I think the last justice to come out of the non-Ivy League was Justice John Paul Stevens, who went to Northwestern University. So,
Did
okay,
Justice Stevens clerk? Do you happen to know if he clerked for another justice? Usually that also happens. They clerk for a justice, and that kind of gets them in also.
Right,
Yeah.
because Judge Barrett clerked for Scalia. I mean,
Yeah,
yeah,
but-
Scalia.
yeah. I believe Justice Stevens, when I read his biography, he served in World War II, and then he got a GI Bill, and then he just went right to law school after that, and then he was in private practice, and then at some point, Nixon appointed him to be a Supreme Court justice. And by the way, he was very conservative when he was nominated, but by the time he retired, just 11 years ago, he was probably one of the more liberal justices. Very strange. All right, 2 more hands, and then we're gonna try to wrap it up. So let's go with Caleb, then Amber.
Yeah, I was just gonna say before we went into this tangent, which I think was productive actually, I heard a lot about like democratizing the Supreme Court. In other words, trying to make the Supreme Court fit the opinions and the kind of outlook of what people are thinking in the country at the moment. So in other words, we're trying to get polls out and seeing if, based on the polls of like certain opinions on certain things, whether these Supreme Court justices fit the mold of our current political climate or whatnot. And I think someone said that they feel that they're being ruled by a minority. In other words, the majority of people are feeling, a majority of people have an opinion, and that opinion is not being reflected in the courts. I think I can understand this on an intuitive basis that this, I get that, the frustration, but the Supreme Court or the judicial branch is not the place for what we're talking about, like democratizing, having new ideas being, reflected in these judges or in the judicial branch as a whole. That is left for the legislative branch. And I think that's the point. When you elect a senator or vote for a representative, you are voting on them based on how they view things and what their policy agenda is based on what their constituents believe. And I think there is a better argument or a stronger argument to abolish the Senate, which I'm not suggesting, but I'm just saying there's a stronger argument to say that we should abolish the Senate to democratize the legislative branch, which is the point of the legislative branch is to express the will of the people. Then there is an argument to democratize the Supreme Court. The Supreme Court isn't meant to be an expression of the will of the people. It's meant to be an institution that resolves conflicts between laws. And I think, again, we are seeing the failure of the legislative branch, which is we don't feel like the legislative branch is doing enough of its job. And we're trying to, almost like a sick person, when one part of the body is hurt or not doing its job, the other parts of the body have to make up for the weight. And I think the Supreme Court is trying to make up for the weight that the legislative branch has been dropping. And I think the executive branch as well has been doing the same thing. When you think about the number of executive, what you call them, is it called executive actions? Or whatever you call them?
Executive orders.
Or executive, there you go. My brain just clocked out for a second. But executive orders that presidents have been doing increasingly throughout the years, especially Donald Trump, it's because the legislative branch is not as effective as it should be. So I think the conversation we're having about the Supreme Court is more because of our frustrations with the legislative branch and how it's not representative enough or how it's not doing enough for us. And yeah.
If I could just
I would
say
agree
one
with
thing
you, but
about-
Citizens United is a glaring example of the court going in the complete opposite direction.
Yeah, but what I'm suggesting is
you're saying they're there to interpret the laws as they exist.
No, I'm not saying that they're doing that. I'm saying that was their role. And I'm saying the legislative branch, the judicial branch is taking up the weight from the legislative branch and is doing what exactly you're saying, which is legislating from the bench. And I think they have been. I think there are many Supreme Court decisions that are basically just legislative in quality. Although they based them off like court opinions or court the interpretation of the certain laws. So
okay.
There
We do need to wrap it up. I get your point, Caleb. Another interesting factor into this is there's another outgrowth of the executive branch called the administrative agencies, and the courts are very skeptical because this has become almost like a fourth branch of the government. They're not accountable, they're not elected, they're just appointed by the executive branch. So agencies like the EPA, Department of Energy. So the question is, when they undertake certain actions, well, what kind of review are they scrutinized under? So this is a very contentious area. But anyway, not to get off point, but so I think to underscore Caleb's point is that yes, there has to be a number of reforms, and that could be, kind of reining in the administrative state, if you will, as well as doing some kind of like a reform for gerrymandering, because obviously, given the hyper-polarized nature of these districts, you have these candidates who are in a very safe district, and they don't maybe necessarily represent the voters writ large. We have time for two more points. Let's go to Sandy, and then after that, Amber. Go ahead, Sandy.
I was just trying to think, if the Democrats aren't able to expand the court, what could they do to try to restore a little bit of balance on the court? And one thing might be that they could try to free up some of the current seats on the court. So for example, when Brett Kavanaugh was undergoing his confirmation, a lot of really alarming allegations came out, but somehow they shut down the investigation into that. So we weren't really able to find out sufficiently whether those allegations were true or not. So at this point, maybe the Democrats could just pick up the investigation on their own. They could go, if they found some things, then they could go to him quietly and say, look, we have 12 girls who are all saying the same thing about you, and we have 8 of your friends who confirmed it, and we have this kind of physical evidence to back it up. So, do you want us to come out with a story and embarrass you, or do you want to just step down now? And then we would have a spot if Biden was elected and he could put someone liberal on. So there's things like that we could do. And, it's a Republican strategy, but Democrats have to start thinking this way now.
Sounds like I'm hearing like an impeachment strategy for a sitting justice. Is that right?
Well, the impeachment is really hard. I think you need 2/3 of the Senate to approve that, and that's going to be hard to get. So not impeachment, like a closed door, dude, we have the dirt on you. Do you want us to expose you, or do you want to just step away quietly and then leave the seat for us? I think that would be a lot easier to accomplish.
Okay. Amber, last point. Go ahead.
I wouldn't want to get on Sandy's bad side. After listening to all this, the thing that keeps ringing in my ears is this sounds just so antithetical to the American ideal. It's like, we don't want a monarchy, but we literally have people in black robes who have lifetime appointments, who are not elected, and who basically make decisions on things. And yes, they have to follow some strict guidelines with the Constitution and law and stuff like that. But my mother was a legal secretary to a very good corporate lawyer, and you can basically, make your case for anything. So it's scary to think about, but at the same time, there are just so many roadblocks set up to not make any type of change. I mean, I know Caleb was saying that, well, you have to vote for, the representatives to represent you and your ideals and everything like that. But we have something called the Electoral College that stops that. So even if the person who wins the most votes, it still can lose an election and literally have a whole swath of the minority group ruling the majority. So at first I thought, okay, well, this is a good idea because you need some type of checks and balances, but now we're off the rails. Like when you have a rogue Senate and a rogue president, and now you have a rogue judiciary, it looks like, Supreme Court, how do you fix this? It's not something that can just easily be voted out or voted away. Democrats have to take some real steps to making sure this doesn't happen again. So although I still don't think it's #1 top priority for us to be worrying about the Supreme Court right now, if it were, I don't see expanding the court as a bad thing. Make sure that it's, balanced. You have the same amount of Republicans and the same amount of Democrats, and then you have a couple of extra people who are in the middle to be tiebreakers. But saying that we can continue the way we are doing right now is just not feasible, because at this point, I don't know anyone who takes the Supreme Court seriously anymore. And it started off as, okay, well, they're just not doing what you want them to do. And so, like you're just it's just sour grapes, to, we're basically confirming someone in the dead of night, like who has literally no, experience, and should not be on the Supreme Court. because somebody is a power hungry. So it's really scary, but at the same time, like there's not much we can do. And so if expanding the court is the only option that we have to make, then just make it. But again, if you expand it to 13 and they come back and expand it to 20, it's just going to keep going and going. But there has to be a way to check the Supreme Court. This is untenable. We don't have, we have impeachment, but like Sandy said, it's a 2/3 vote. So that's almost out the window. Pretty much sounds like coercion, telling them, like we're gonna show or blackmail, telling them to step down or we'll get dirt on you. So I don't really, this sounds a little bit like what something Kim Jong-un would do, and I wouldn't really approve that. So the only thing I can think of is expanding the court.
Okay.
Actually, it's something Republicans would do. And if that's what your opponent does, then sometimes you are forced into doing things like that too. So in a better world, we wouldn't resort to this, but this is where we're at. So.
Okay. So as we sit here today, we are 5 days away from November 3rd. So the final question I want to bring up to everyone. Sorry, Pedro, we're out of time for your question. So chances are, more likely than not, we're going to end up in some kind of like a post-election litigation. Probably something like, Trump versus Biden, just like Bush v. Gore, instead of the state of Florida being the heavily contested state. It's possible that we could have a number of states throughout the country, a lot of these swing states. So the burning question really is, if this ends up going all the way to the US Supreme Court, what should Justice Barrett do? Does she have to recuse herself, or can she be part of the bench to hear these cases? What do you think? And that's a very real likely scenario, I think. So let's hear some opinions. What do you think? Anyone? Recuse? Sandy?
Can I just ask a quick question that piggybacks off yours? I see that the Supreme Court is coming down on different opinions on when different states can count the votes after Election Day. Why are there so many differences?
Because each state has different laws about how the votes are counted. I think right now, there was a case from, I think, North Carolina saying that not North Carolina, sorry, Pennsylvania, where they said they could count the mail-in ballots 3 days after November 3rd. So
No, they can accept them even if they arrive 3 days after, but the counting of the ballots takes longer than just 3 days after the election. Ballots don't, electors do not have to be, sorry, Lorraine, to go back to yours. The reason there's so many different ones is because the election laws lie in the states. The states get to decide how elections are carried out, how the slate of electors are picked for the electoral college, etc. Now, as far as the slate of electors don't have to be certified until, I could be wrong about the exact date, but I want to say it's like December 12th. I have a question that I had assumed, and I don't know where I heard this or I read this, and I have to go back and look at it for the actual wording. What I don't get is why this has to go to the Supreme Court and not to the House of Representatives, if there cannot be a slate of electors that are picked, or if there's an issue with it. But maybe that's also because there's an electoral college that picks the president as opposed to, I don't know, Democratic rule.
Yeah. I think you're right. I think it is December 12th is when the results have to be certified. All right, so let's go to some other points here. Again, the question is, does Justice Barrett, does she have to recuse herself or not? Ralph, then Sandy.
Okay, yeah, a couple of points. One is, I don't think she has to recuse herself if she had a personal interest in the outcome, but she clearly doesn't. Or if she had been part of the case, she had been involved in the case that was being brought to the Supreme Court, then she would have to recuse herself. But simply having an opinion on the subject has never been an issue for recusal, only if she has some direct connection to the specific case being brought. Let me go. And the reason why these cases come to the Supreme Court is because they are issues of law, and they so the question, as people mentioned, the voting arrangements are strictly state law according to the Constitution. There's no constitutional rules generally on voting procedures. And as I understand it, the Supreme Court, in the decisions it's made on voting, some of them have been sort of more in favor of open voting, and some have been more restrictive. But in general, they've overturned federal district court decisions, and they've supported state court decisions. So their position has been that this should be a matter of the states, and the federal government, the federal, particularly the Supreme Court, should not intervene, except to overturn district court rulings that change the state legislative or state court decisions.
Okay. Sandy.
Yeah, I think Ralph's right. I think there isn't a law that says that she has to recuse herself. So, according to that, she doesn't need to. But I think a lot of people view her as kind of illegitimate under the circumstances in which she came in. So if she ended up being the deciding vote in, say, a Trump versus Biden case, I think there would be just mass outrage. So, but she's not going to do the moral thing. If she had morals, she would have said, you know what, I don't think I should be appointed under these circumstances. Let's wait until the election results are in. But she didn't do that because, she's not trying to do the right thing here, in my opinion.
Okay, anyone else? I guess I'll just mention one thing. When that question was posed, whether if she would recuse herself, she didn't answer. And whether if she could control the appointment of her nomination, I mean, that's beyond her control because that's based on, when the seat becomes vacant. But the answer to whether if you would recuse yourself, she did not answer. And I think you could certainly make an argument that, well, these justices have this image of, well, we're just, independent, neutral arbiters. But if you dig deeper, no, they're not. In fact, I think there was an article that was posted saying that 3 of the justices right now, that being John Roberts, Brett Kavanaugh, and Justice Amy Barrett, they were all involved in Bush v. Gore litigation. So to say that they were just these, independent arbiters of, wearing black robes and deciding cases, no, they're actually pretty activist when it comes to partisan politics. Now, they could say, well, we're just performing, a good service to our community, but that community happens to be very partisan. So whatever the outcome is, I think if you are looking at it from the outside, again, away from the US, if you look at what happened in 2000, Bush v. Gore, and then you look at what happened now, just the timing certainly gives a lot, like a shroud of illegitimacy because of this fast track nature of this nomination. And then if it really comes down to 5-4, and if it turns out to be Justice Barrett being the tiebreaker, well, boy, that seems like nothing but losing credibility. So,
well, no offense, but she also didn't answer the question of whether or not voter intimidation was illegal. And I mean, that's like a federal law, which was something that she just claimed she couldn't answer because she didn't want to, I don't know, telegraph her possible future rulings or decision making, which I find to be, excuse my language, total bullshit. It's not even hypothetical. Amy Klobuchar specifically said, is there like currently a law that prevents voter intimidation? And she's like, I can't answer that. You can't answer something that is a federal law, but you want to be on the Supreme Court. Anyway. Okay. All right, we have 2 more hands and then we do need to wrap it up. So Pedro, then Ralph. And after that, we have to wrap it up. Go ahead, Pedro.
So mentioning what you mentioned, Thomas, about the justices being involved in Bush v. Gore, but that goes back to Sandy's point in that, like, they're even in the federal level, their decisions are still being monitored. When they're federal court judges or when whatever they choose to do throughout their career, they're trying to make it to the Supreme Court if they're ambitious, and so ruling in the right ways is very important. And I mean, I see this I'm an immigration attorney. I was an immigration attorney for Catholic Charities San Diego for 8 months prior to COVID. And I saw it with the immigration judges. They have quotas, they have literal quotas, and they are motivated to rule, to deport, or we call it removal, but it's deportation. And so they have these quotas to get there. Usually they were ICE attorneys very, very party lined, appointed. They're not appointed for life, but they are appointed. And when they get there, they have to rule in a certain way. And honestly, sometimes it's not me versus the other attorney. It's me versus the judge. It's like, so I've been in cases where the opposing counsel, the ICE attorney, doesn't have to do anything. He just sits there, and I have to argue against the judge, and the judge is doing the opposing counsel's job for him. And that usually happens when the opposing counsel isn't prepared. The judge steps in and they take the position of this person should be deported. And they're supposed to be a neutral arbitrator. They're supposed to be completely neutral, but they're not. And that's because of the entire politics. They want to keep their position. They want to stay as IJs, immigration judges. And to do that, they have to maintain their quotas. They have to deport a certain amount of people. And even then they can still be promoted to a federal judgeship if they did a good enough job. So their decisions to be involved in litigations and Bush v. Gore or whatever, it's all either a move to keep them in their position or to get them to a federal judgeship, which usually more than likely they're happy with, because those are also lifetime appointments. Or they'll go to the Supreme Court, at which point hopefully they'll snap out of it and they'll start actually litigating on what the law is, what their conscience dictates, as opposed to what party politics say. But well, I mean, I just wanted to put my 2 cents in that as far as what goes on as far as their decision-making process. Because Andy, honestly, that was a really, really good point. That it's a ladder, and they're trying to get up it.
Right. Just to buttress that point, I have colleagues who are also immigration lawyers, and there's a scorecard. So if you don't deport a certain number of petitioners, then well, your job's on the line, and your scorecard is based on the number of removals plus how many cases are appealed and reversed against you. And a colleague of mine showed me the transcript of her court proceedings, and the judge even says that if this case were heard under Obama administration, the outcome would be a lot different, but my hands are tied. That's the exact quote that I saw in the transcript. My hands are tied under the current administration. There's nothing I can do. There's a new standard. I'm sorry. And they basically deported this person from their country of origin. Okay, one last point.
You'd be surprised what stuff goes on in those courtrooms, the things that are said that don't get on the transcripts. But yeah, that is.
We're not surprised. We've seen the pictures of where they keep those children. Trust us, we are not surprised. We just want y'all to speak up about it when you can.
Ralph will have the final point. Go ahead.
Okay, finally, just a comment on Tara. I think the sort of rule has been for the last couple of decades that in a when a nominated justice is up for things, you don't answer any questions. You don't give them any material. Just say, well, I don't want to prejudge any other decisions. Well, I can't answer speculative questions. The rule is you just don't say anything. That's the best way to get through the process. And their goal is to simply get through the process and get confirmed. And that's perfectly rational.
I mean, I'm going to have to disagree on that particular one because it's a federal law, but I get what you're saying in the spirit of what you're saying, but she couldn't name it's probably a slip of the tongue, but she couldn't name the 5 rights enshrined in the First Amendment, and also could not tell you, yes, voter intimidation is illegal. That is not deciding on a partisan basis, or like it's a law. It's a law.
Okay. Why don't we leave it there? I do need to sign off, have another engagement, but we have another meetup coming up this Saturday, and this will be the final, I guess, meetup before November 3rd. And we're going to have a bunch of people coming on to talk about why Joe Biden should be elected as president. It's our part 2 of closing arguments. So hopefully we'll see you at that discussion. If not, take care, and we'll probably see each other after November 3rd. All right, folks. Good night.
Thank you.
Yeah.
Thank you.